Module 3. Topics involved. The liability that you as a server can be accountable for. Information to be covered in this unit. Number 1. Dram Shop lawsuits. Number 2. The potential legal consequences of overservice. Number 3. What you can be sued for. Number 4. Civil lawsuits for serving a minor. Number 5. Who can sue you. Number 6. Damages you would have to pay. Number 7. Criminal liability. Number 8. How to protect yourself from a Dram Shop lawsuit, also known as a third-party alcohol liability lawsuit. Number 9. Using a logbook. And number 10. Alcohol server policy. It is important for you to understand that there's more to serving alcohol than most people realize. This module will help you in your serving decisions. Dram Shop Act. What is a Dram Shop Act? The state of Michigan has specific laws dealing with lawsuits against businesses that sell alcohol to the public when the sale results in the personal injury, death, or property damages to another. This law is commonly known as the Dram Shop Act, the law found at MCL 436.1801. In 1986, the Michigan legislature made substantial modifications to the Dram Shop Act. Subsection 3 of MCL 436.1801 sets forth the cause of action as follows. Except as otherwise provided in this section, an individual who suffers damage or who is personally injured by a minor or visibly intoxicated person by reason of the unlawful selling, giving, or furnishing of alcoholic liquor to the minor or visibly intoxicated person. If the unlawful sale is proven to be a proximate cause of the damage, injury, or death, or the spouse, child, parent, or guardian of that individual shall have a right of action in his or her name against the person who, by selling, giving, or furnishing the alcoholic liquor, has caused or contributed to the intoxication of the person or who has caused or contributed to the damage, injury, or death. In an action pursuant to this section, the plaintiff shall have the right to recover actual damages in a sum of not less than $50 in each case in which the court or jury determines that intoxication was a proximate cause of the damage, injury, or death. Although most of the cases have involved an actual sale, the statute makes clear that the giving or furnishing will also suffice. The Michigan Court of Appeals decided that a bar employee serving herself intoxicating liquor constitutes an unlawful giving or furnishing where there is no indication that the taking of the liquor was in violation of the employer's orders. Michigan Compiled Laws Section 436.1801 can be used to hold an alcohol vendor liable for an alcohol-related accident if the vendor's providing the alcohol was a proximate or foreseeable cause of the injury. The vendor's liability is not automatic. However, in order to be deemed legally responsible for the underlying accident, the vendor must have provided an unlawful selling, giving, or furnishing alcohol either to a minor under age 21 or a person who was already visibly intoxicated. The requirements of the statute vary depending on which of the two types of unlawful sales is involved, an unlawful sale to a minor or an unlawful sale to a visibly intoxicated person. There are three parties involved in a Dram Shop lawsuit. You have the first party is the drinking party, that is the customer. The second party is the serving party, that is you and the establishment. The third party is the person or property outside of the alcohol transaction, the person who is injured, the property damage. Here's the way it breaks down. Mrs. Jones comes into your bar. She sits down and you serve her some Merlots. And after a while she'll say, "A swarm Merlot, please." You're like, "Hey, okay, drunk lady, you're done." She says, "Excuse me, I'll tell you when I'm done drinking. I'm going someplace else that will appreciate my business." She then gets up and leaves, and you do nothing to stop her. You might make a comment to her like, "Are you okay to drive?" And Mrs. Jones says, "Yep, I'm fine." And she heads out the door. While she's driving down the road, here comes Mr. Smith, and she crashes into Mr. Smith's car and hurts him really bad. Here's what can and probably will happen. Mr. Smith will sue Mrs. Jones for hitting her, and then Mr. Smith can sue you and your establishment for overserving Mrs. Jones. These are not new alcohol lawsuits. They originated in England. They are part of the common law. Here's a quick trip to law school for you. A tortfeasor. A tort is a civil wrong. The category that you as a server can fall into is negligence. This tort requires 4 elements for it to be completed. Number 1, a duty to another. This is created by common law. Common law has decided that as a common to the area where you reside, and if you serve alcohol to someone to the point of visible or apparent intoxication, you should get this person to safety. Yeah, you call them a cab, you call their friend, their spouse, or they just sit there till they get sober. Remember, if somebody is intoxicated at your establishment, not causing a problem, purchasing, possessing, or consuming alcohol, they are welcome to stay, as long as they are eating food, seeking medical attention, arranging transportation that does not involve driving himself or herself, or any other circumstances where requiring the person to vacate the premises immediately would be considered dangerous to that person or to the public. Number 2, was there a breach of this duty? Did the server do nothing to stop this person from driving or walking away? Number 3, proximate cause. Was it foreseeable that this individual who was now intoxicated, that if they drove or walked away, that something bad could happen? Obviously, yes. And number 4, you have your actual damages. You've got your tangible damages such as property damage, lost time from work, medical costs, etc., as well as your intangibles, i.e., pain and suffering. A Dram Shop Act is this. If you overserve someone alcohol, you can be held directly accountable. So don't overserve. The problem is, it will happen. When someone drinks alcohol, they're going to become affected. It could be because they started at home, they're mixing it with drugs, they have a low tolerance. There are a lot of different variables which can make it difficult for you, a server involved in the service of alcohol, to protect yourself from a potential Dram Shop lawsuit. What are the potential legal consequences of overserving? You have 2 of them. You have licensing consequences, you have civil consequences. Licensing consequences. You lose your livelihood. Your employer loses his license also. Civil consequences. You lose your home, your life savings, and whatever else you've accumulated. The licensing consequences are relatively straightforward. If you're caught, you lose your license. The civil consequences require more in-depth treatment. When looking at the civil consequences, there are a few specific questions you need to ask. What can I be sued for? Who can sue me? What types of damages will I have to pay? Michigan Code MCL 436.1801. The law states in pertinent part that A retail licensee shall not directly, individually, or by a clerk, agent, or servant sell, furnish, or give alcoholic liquor to a minor except as otherwise provided in this act. A retail licensee shall not directly or indirectly, individually, or by a clerk, agent, or servant sell, furnish, or give alcoholic liquor to a person who is visibly intoxicated. Important things to remember. You can overserve someone even if you have no evidence that they've had anything to drink beforehand. The only question is whether they appear visibly intoxicated, apparent to an ordinary observer. Now, you might ask the question, I can overserve someone if they've been drinking someplace else? Basically this. The ones who come in, they have one drink, suddenly they're intoxicated. You now realize that they have been drinking someplace else before they came into your establishment. The problem is you have overserved them. Then you've got the old seasoned pro, the ones who sits there and puts one drink down after the other. Even though you know that as many drinks as they've served them, and you know that they should be buzzing, and they're not showing the signs of intoxication, that can come back and bite you. Remember this, being that the highest blood alcohol content level is achieved between 30 and 60 minutes after consuming alcohol, and it can plateau for 2 hours thereafter. Then you've got the boys who want to settle things outside the old-fashioned way, little fisticuffs. Well, if you serve someone who is obviously intoxicated and that a person assaults someone else, you could be liable to the person who is assaulted. In 1997, a Dram Shop Act lawsuit saw where 2 men got into an argument in a restaurant bar and were told to leave. They went outside and the fight escalated. One man bashed the other man's head into the pavement. The other man suffered brain damage, memory loss, and chronic headaches. That restaurant was held liable for those damages, which were in the millions. Now, what happens if you serve a minor? Well, serving any liquor to a minor, if that minor is intoxicated or not, can lead to civil liability lawsuit for any act that the minor does. But you can protect yourself from some liability if you check the buyer's identification by diligent inquiry.